Good morning, everybody. My name is Sarah Krom. I'm managing partner of SKC and Co CPAs, and welcome to our office hour for the month of May. We are here today to talk all about cannabis. We have a really great panel of participants today, and we are excited to give you a lot of content. So as you know, if you've joined us before, this is being recorded. So if you or any of your colleagues wish to revisit this, please share the link. You will receive it in an email later this afternoon. I do want to introduce Karen Donaway and Brittany, our marketing team, who join us and help manage our chats. Please, we want to make this as interactive as possible. We want this to be incredibly valuable to you and exactly what you want to get out of it. So feel free to interject questions in the chat throughout the morning, and we'll be happy to get to them. If we can't get to them because of our time allotment, we will be sure to reach back out to you via email so that we can get your questions answered. So with that, let's jump in. So the passage of adult use medical marijuana in New Jersey, what does it mean for your business on the liability and the employment law side, and what industry you're in, as well as what does it mean if you want to invest in this space? Two very different topics surrounding adult use marijuana, but incredibly important, and we're going to cover them both today. So we have Keya Denner. He is partner at Ford Harrison LLP. He's going to be covering the employment law side of things, and he specializes in employment law, executive compensation, and cannabis law, and he's the co-chair of his firm's cannabis law practice. So welcome. And then we also have Melissa Dardani. She is the founder of MD Advisory Services. She is a CPA and certified fraud examiner, and the leader of the New Jersey Society of CPAs Cannabis Interest Group. So we have a lot to cover. We have a great pair of experts. We're going to jump in with a quick poll. We want to get a pulse on who is in our audience and why you guys have joined us today. So Brittany, if you want to go ahead and sort of pull up that poll, we can see where our audience is. So really, we just want to know this morning, why are you joining us? Are you joining us because you're interested in the topic in general? Do you want to get involved somehow in the investment space, or do you want to learn how to protect your business from any type of liability surrounding the legalization of adult use marijuana? All right, Brittany, you want to share those results with everybody? Okay. So we don't have a lot on the investment side, but we're gonna dig into both topics, and we're gonna get started right now. So let me just sort of jump into some background on cannabis in New Jersey. If you can remember back to the ballot question that we had in November of 2020, whether or not we should legalize adult use marijuana in the state, that actually passed with a 67% approval. And so then officially adult use marijuana became legal in New Jersey on January 1st, 2021, and Governor Murphy signed bills and various different legislations effective February 22nd, 21, which sort of provided an infrastructure and some parameters around what the adult use licensing and things like that meant for our state. But actually, it's now been April 21st of 22, almost 2 years now, that licensed sales of recreational cannabis started in New Jersey. And there's currently 13 licensed dispensaries in New Jersey, in case you guys didn't know that. So Keya, can you kind of start us off with a little bit of background on federal versus state with the legalization in New Jersey, and what actually a Schedule I drug does mean?
Sure. Thanks, Sarah, and thanks for inviting me. I'm happy to talk about this topic. I get this question a lot, especially when I talk to businesses who might be in states that have legalized adult use cannabis or have a medical marijuana law. And, you know, there's kind of this general like, wait a second, I don't understand. How can the state do this, but isn't it still illegal under federal law? And it sounds like a basic question, but it really is a hump that people need to get over. So, you know, basically the way this shakes out is, yes, it is still illegal under federal law. It is a Schedule I drug. And what that means is under the Controlled Substances Act, it is supposedly has no recognized medicinal value, and it has a high potential for abuse. So if you're on a Schedule I, you have to meet that criteria. So as I said, currently cannabis is still there. It's there with other drugs such as heroin, LSD, ecstasy, you know, other drugs that meet that definition. Now, on the federal side of things, that doesn't mean things have not been changing, and they have been kind of progressing. I'd say since about 2018, that's when we started to really see some progress here, at least on the federal side, to kind of chip away at that and recognize first and foremost that it does have some medicinal value. And in 2018, the FDA approved for the first time a drug called Epidiolex, and that was used to treat epilepsy in children. And that drug was important because it was the first drug that was approved by the FDA that was derived from cannabis. It's not a synthetic drug like Marinol. It's coming right from the plant, which is, again, supposedly a Schedule I drug. And the DEA then descheduled that. So you start to see that, we're moving along those lines. I don't know, as we sit here in 2022, when is this going to happen on the federal level? But it seems to be moving that way. And we've had, again, since 2018, there's been some steady progress in the legislature, in Congress, to kind of get bills that would legalize, either deschedule it, decriminalize cannabis, to at least move those out of committees into votes. And even though they haven't been passing all the way, that's still a pretty big accomplishment, because 10 years ago, none of these bills were even getting out of a committee. I mean, they were just on some progressive senator's desk and just talked about. So the fact that they're actually getting up there for votes, and you have, like Senator Schumer is like pushing this forward. Again, I don't know, it's a political issue whether or not it's going to actually happen one day, but we've had it. And so we've had things like the MORE Act by Senator Nadler in 2021. And again, these things keep getting pushed through. So that's kind of where we are on the federal side. And, just as to what's going to control, that kind of goes back to, I'd say, 2010, 2011, 2012. In the Obama administration, we basically started to see more states passing medical marijuana laws. We started to see more states passing adult use cannabis laws. And so what we saw on the federal government side, from the Attorney General and from the DEA, was kind of this policy of hands off. We're going to go after the drug dealers. We're going to go after businesses that are not following state law. But if you get a license and you're in a state that allows it, generally the federal government, their policy has been, we're going to be hands off. And that's kind of crossed party lines. So we've seen that policy kind of stick through, even through the Trump years. When we had Jeff Sessions come in at first, he kind of talked the game like we weren't sure, is he going to now change the enforcement policy? But ultimately he didn't, and Trump didn't. So here we are. And Biden's kind of, quite frankly, there's been other things to worry about with the Biden administration. So, again, we're kind of in this area where, as long as you're following your state's law and you're going through that process, the federal government is generally not going to be kicking down doors to enforce cannabis law and claiming that it's a Schedule I drug. If you are involved in any criminal element, and there could be any indication that you're doing something more in line with drug dealers, for example, then it's fair game. So that's basically where we're at on the federal side. And so, as I said, and let me just also say, so we have, let's see, about right now we have 36 states which have medical marijuana, and we have 19 that have adult use. Okay, and when I say adult use, I mean recreational. So that's moving forward. And as you can see, we have a majority of states in the country that have medical marijuana laws. And a little preview of what we'll talk about in a few minutes. 18 of those states have protections for employees that use medical marijuana. And we'll talk about that in detail in a couple minutes.
It's a good teaser. Thanks for that. So let's actually jump into what business owners need to know across the board from an employment law standpoint. And we're going to throw up our second poll question just to see how plugged in some of our audience members are. And that poll question is, have you updated your employee handbook yet to cover the legalization of adult use marijuana? We were talking about this before we started the 9 o'clock call this morning, and really, I would imagine, I'm looking at some of the results as they come in, this is exactly where we anticipated them being, that, as business owners, we're not really paying attention to this from an employment law standpoint. So Brittany, if you want to share those results so the audience kind of knows where each other is, I think that there's certainly a lot of work to do here, and that's exactly what we're going to accomplish. So regardless of the industry that you're in, there is absolutely employment law and human resource issues to contend with here. And, Keya, we're going to jump into the first thing that pops to people's mind. And I know that we've done this before at SKC for employment, drug testing. So what do we do with this new law? Do we continue to do pre-employment drug testing? Are we still able to do random drug testing? Do we need to tell either employees or prospective employees that we're going to be testing for marijuana and a positive result is a failure? I mean, there's a lot just in this question.
Sure. Okay, so yeah, let's start. And the way I like to present this is kind of in two different parts, because we actually have two different laws in New Jersey. We have the medical cannabis law, which is called the J. Koenig law. That was amended recently in 2019, but it's actually been around. We've had medical marijuana in New Jersey since 2010. And then we have the new adult use or recreational marijuana law, which, Sarah, you had kind of given us a little bit of a timeline when you started out today. And both of those laws speak to employment protections for an employee who either has a medical marijuana card or somebody now who's able, because they're an adult, to go ahead and, for example, on a Saturday, go pick up cannabis and just use it, in the safety of their own home or whatever they want to do. And so both of those laws, both of these statutes now have some employment protections in there. And both of them speak to drug testing. As we'll see in a minute, unfortunately, not very clearly, but they speak to them. So let's talk about the medical marijuana statute for a second. And so, as I mentioned a second ago, the law was actually amended in 2019 to add some employment protections. Before that, there weren't really any employment protections in there, and the law was the subject of a couple court cases, and actually one case went up to the New Jersey Supreme Court. But that's kind of, at this point, ancient history, because now we do have a statute that's been amended. It speaks to employment protections. So what does the J. Koenig Act say? So it contains a provision that says that it's unlawful for an employer to take an adverse employment action, which is a term of art that us employment lawyers like to use, but basically that means not hiring somebody or firing somebody. So it's unlawful for a company to take an adverse employment action against an employee who is a registered patient solely based upon their status as a registrant or a marijuana card holder, let's say. Okay, so what did I just say? That basically adds, we're all familiar with equal employment opportunity laws, right? As an employer, you're not supposed to discriminate against somebody because of their sex or their gender or their race or their disability, et cetera, et cetera. There's a whole laundry list in New Jersey and also in all states. So what this does is this adds another category. This says if you have a medical marijuana card, you now are protected. You can't be discriminated against based upon your status. Okay, so that's what that says. And then the statute also says employers, you can have a drug testing policy, and you can go ahead and you can drug test employees or job applicants. However, if they test positive for cannabis, what the statute says is the employer has to offer the employee or the job applicant an opportunity to give some explanation. What they say is present a legitimate medical explanation for the positive test result. And you have to give written notice of their right to do that. So you got to give them a right to explain, hey, this is why I tested positive for cannabis, and you got to do that in writing. And furthermore, the law says within 3 working days after you give them that notice, the employee or the job applicant then has to come forward and give some explanation. And then the law says, as part of the explanation, or maybe all of the explanation, they can produce their card, their medical cannabis card. Okay. Unfortunately, the law just stops right there. It doesn't tell you what to do once they do that. But what I tell my clients, and the way most of us interpret this law, and again, this is only 2019. So the other thing here is there's no cases out there. So we haven't had court cases yet that have gone all the way up where we've had written decisions about this. But what I tell my clients is, look, bottom line is, if they test positive and they give you a card, you can't do anything to them. You got to hire them if they're a job applicant. And if they're a current employee, you shouldn't fire them. So again, it's kind of nuanced, but for the most part, that's what we tell folks, is that you're protected if you have a card. Okay. Now there's a couple carve outs to this. Okay. The law specifically says that this doesn't mean you have to allow employees to be intoxicated at work. Okay. And by the way, same thing with recreational. So everything I'm going to talk about this morning, when we talk about protections for employees, this doesn't mean that you have to let people show up to work, medicate while they're at work. Just because somebody has a medical marijuana card, you don't have to let them go out on lunch and smoke a joint in their car and come back in and they say, hey, it's because of my glaucoma or whatever. You don't have to do that. And if you think that somebody's intoxicated, we'll talk about that in a second in terms of like best practices and what you should be doing. But again, that's a really important point. We're not talking about using at work or possessing at work. So if somebody has cannabis on them at the workplace, you can have a policy that says you can't do that. Certainly things like distribution and selling at work, those are all things you can prohibit. So basically this is pretty much, for the most part, talking about activities that folks do on their own time outside of work. So there's also a couple carve outs for if you happen to, for example, be a federal contractor. You have a federal contract, or maybe you get grant money from the government, and you would lose federal funding if for some reason you didn't disqualify a job applicant, for example, because they use cannabis. So you can think maybe, for example, maybe you're a military contractor with the government and they say, look, as part of the contract, you have to do drug tests. And if anybody tests positive, whether or not they have a medical marijuana card or not, you can't hire that person. We don't want them working on the project. Those are things that are carved out. A more practical example is if maybe you're a truck driver, you have a CDL, commercial driver's license, you would be governed by Part 40 of the federal regulations, the DOT, Department of Transportation regulations that specify when somebody needs to be drug tested and pulled off the road, for example, if they test positive for marijuana. Those things would be carved out. Okay, let me move on now to the adult use. Okay, adult use, just like Jay Conning and just like the medical, has a non-discrimination provision. And what that says is that employers can't refuse to hire a job applicant or fire an employee because they use cannabis. It's pretty broad. Because they use cannabis in accordance with the adult use law. So one thing to think about here is if you happen to be an employer who employs 19-year-olds, 20-year-olds, this might not apply to you. Remember, adult use is 21 or over. So, but for all of your adult employees, you can't refuse to hire somebody or fire somebody because the person legally uses cannabis. And you can't take adverse action based solely on the presence of cannabinoid metabolites in their bodily fluids. Okay, what's that second part I just said? Basically, that means if you drug test somebody and they come up positive for THC under this brand new law, this says you can't fire somebody solely because they tested positive for THC on a drug test. That's important. Okay, here's where it gets a little weird. It says that, But then the statute specifically says you can drug test people. As an employer, you can still have drug testing policies. And you can test people under a few circumstances that they list in the statute. Number one, you can test somebody under reasonable suspicion, right? So if you observe, maybe one of your employees observes somebody stumbling through, basically any kind of reasonable suspicion testing, the statute allows you to do that. The statute also allows you to test post-accident. Somebody they're driving the company vehicle, they get into a car accident, you're allowed to drug test them after that. The statute also says you can conduct random drug tests. The statute also says you can conduct pre-employment screening. So you can drug test applicants. So the problem here is that the statute is kind of at odds with itself. It says you can do these drug tests for all of these reasons. And furthermore, it even says you can use the results of the drug test to make an employment decision. But again, if you remember a minute ago, I said the first sentence of the law says you can't fire somebody solely because they test positive for THC. So just think about that for a second. The statute says you can drug test. The statute says you can do pre-employment screening, right? But then it also says you can't fire somebody solely because they have THC in their bloodstream. So practically, again, what I've been telling clients is, basically, especially for pre-employment screening, it doesn't seem like you have the ability to not hire somebody because they test positive for cannabis. You can test them, but apparently you can't not hire them based solely upon the positive test. So I know this it seems a little weird. And believe me, I just spoke at the New Jersey State Bar Association a month ago with a bunch of other employment lawyers, and everybody's basically banging their head on the desk. Like, what does this mean? How do we advise our clients? And there's one other thing about this statute that's unique that I didn't talk about a second ago. And that's that it also says when you do a drug test, there's a couple things they want you to follow here. The number one is pretty simple, and that's that you have to use scientifically reliable testing methods, which if you drug test now, you're probably using a third-party provider, and that's really probably not an issue. I mean, everyone's probably using up-to-date science on this. But the other thing it says is that you have to do a physical examination of the employee when you do the drug test. And they further say that physical examination has to be conducted by a person who's certified to detect impairment. And that introduces this concept of what we call a WIRE, which is a workplace impairment recognition expert. What is a WIRE? Nobody knows. The statute says the Cannabis Commission, the New Jersey Cannabis Commission, is going to work with the state police to come up with a certification program. If you've ever been pulled over by a cop because maybe you were speeding or whatever, and if the police officer thinks that maybe you're impaired, they call in a special drug recognition expert. If they don't think it's alcohol, if it's alcohol, you blow into a tube and there you go. But if they think it's cocaine or any other drug, they call in a special officer who's trained to detect impairment. What the statute appears to be saying is that we want the Cannabis Commission to get with the New Jersey State Police, develop a certification program that all you employers, by the way, can send somebody out. And of course, once you pay your fee to the government and get that person certified to tell if somebody's high on marijuana, there we go. It's a ridiculous, in my opinion, it's a totally ridiculous provision. And the only other thing I'm going to say about it is, thankfully for all of you right now, you don't have to worry about it, because last August, the Cannabis Commission, when they published their first set of regulations, they said, oh, by the way, employers, we don't have this all ironed out yet. So for the moment, you don't have to do a physical examination when you do a drug test. So that's on hold. We don't know what's going to happen with it. And the final thing I'll say about this, because I've been talking for a long time, is that there are some proposed amendments to this law that are on the table right now that would actually help clear up a lot of what I just said. Like, for example, what about pre-employment screening? When can you fire somebody for testing positive? What about the wire? Is it going to be mandatory? I don't know if that's going to pass, but as of a month ago, that was a proposed bill that was, out there. So my best guess is that they will pass some additional law, hopefully pretty soon here in New Jersey, that's going to clear this stuff up. But for the moment, as I said, you can drug test folks, but you have to be super careful about firing somebody because they test positive. And you also have to keep in mind under the medical law that you have to give people written notice when they test positive. I kind of wrap this all up by saying, Sarah mentioned it when she first asked me the question. Pay attention to your policies, to your handbooks, and also think about training for your managers, the people who are going to be observing people. I don't know, if you have a warehouse, who are the people that are on the floor that are looking at people using that forklift or reaching up onto those shelves. So think about training and make sure your policies are really up to date.
I think it seems that New Jersey sort of was a little unaware that back in November of 2020, when we had this on the ballot, that this was all these unintended consequences were going to come out for business owners here and others as well. So it certainly is as clear as mud after you went through all of that.
They shouldn't have been. They shouldn't have been, because there's been other states that were in front of us, and you can look at other states' laws. For example, like Oklahoma, they have a great statute that specifies all of this stuff. And also, one other thing, there is no safety sensitive carve out in any of these laws. I didn't mention under the adult use the carve outs, but they're pretty much the same as what I talked about under the Jay Connick Act. Federal law, federal grant money, those types of things. Noticeably, there is no carve out for if you think your employee is performing some type of safety sensitive job. That is actually probably the number one question I get. Hey, wait a second. We do X, Y, and Z. I'm a doctor's office. I have nurses that handle syringe. Like, it doesn't matter. There is no safety sensitive carve out.
So I want to kind of drive that home a little bit, and I guess I'll ask it this way. And you sort of talked about this when you talked about CDL drivers. Are there different rules for different industries? So in your example about the DOT, somebody who's driving a truck has different federally regulated requirements that they need to meet. And, the cannabis is certainly within that impairment definition. But, there's certainly a difference between an accountant who may sit at his or her desk every day versus someone who is in the construction industry or operating machinery at a construction site or in a warehouse or, hanging off the side of the building, cleaning windows. Those types of industries vary obviously in their complexity and safety issues. Are there any specificities between the different industries regarding cannabis?
So good question, Sarah. As I said, right now, currently, unfortunately for New Jersey employers, the answer is no. The only way you're really getting around this stuff is if, again, you are basically in a position that is federally regulated. So I mentioned DOT Part 40 a while ago. That doesn't just apply to truck drivers, for example, or CDL holders, but basically under that regulation, under that regulatory scheme, they define safety sensitive positions under federal law. And that's pretty much what train drivers, anybody that's using, trucks, of course, but it's kind of narrow. Beyond that, and here's the other thing. If you're an employer right now and you employ somebody who would be covered under DOT Part 40, you know that already. That's just part of your, you probably have a safety person who's up to date on Part 40 regs and what you're doing. So that's pretty much my unscientific test. If you're sitting there thinking to yourself right now, hey, do I have employees who might be covered? If you have to ask yourself that question, the answer is probably no, because you probably already know the answer, that you do have employees that would be covered under DOT Part 40. One final thing I'll say on it is that amendment that I mentioned, that is still out there in the ether, that's just an amendment, that does have a limited safety sensitive carve out. And interestingly, the way they approach it is they say that all these employment protections don't apply if the employee works on what they call critical infrastructure. So, yeah, and I won't even get into the definition of critical infrastructure because it's a law that doesn't exist yet. But I'll just say that it's probably more restrictive than, business owners want it to be.
Right.
It's going to be, people that work on gas lines, for example, and stuff like that.
Right.
It's not going to be like, hey, again, like I own a doctor's office and I got people that are handling sharps or whatever. You can't just designate people as like critical infrastructure employees. So if that law pushes through, yeah, there'll be a limited carve out, but it's really not going to be some kind of panacea or, something that everyone can apply.
So it sounds like at a minimum, as we started with the first, second poll question, do we need to update our employee handbooks? I think the answer to that is at a minimum, yes, we need to, correct?
Yeah, you need to do that. At the very least, you need to look at it and see. I mean, most handbooks have drugs in the workplace or, some type of policy around that. You have to look at and see what that says. And I'll just also say, if you happen to operate in several different states, that's even more important that you look at your handbook and figure out like how you're doing it, because I get a lot of clients that are in multiple states, and the more states you're in, the phenomenon is like they just want one size to fit all. Like, how do we deal with cannabis? Like, what's the deal? You just told me there's 36 states with medical cannabis. We happen to be in like 27 of those. Can we just have some general policy? And usually my answer is not really. You kind of have to have supplements for your handbook because different states do it differently. And that is either the problem or the beauty of our federal system, right? It's like you have states, they can do it different ways. As I mentioned in the beginning, it's still a Schedule I drug, but basically for all intents and purposes, the federal government said, we'll just be over here while you guys figure it out. And so if you happen to be in, different states, especially if you're in, the Southeast and the Midwest and the Northeast, so you're in places that, generally speaking, the Northeast states now are all starting to fall in line with these employment protections. So New York has the employment protections, New Jersey, Pennsylvania has some limited, I think the trend is that all of the New England and Northeastern states are going to eventually have these types of employment protections, maybe not identical, but similar. But places like Florida, you can still fire somebody if they test positive, no questions asked. Georgia, anything goes, so it really depends on where you are.
Great. Thank you so much. I do want to make a transition here over to the investment side of things so we can hear a little bit from Melissa, but Keya is going to stay on for the rest of the office hour. So if you do have specific questions, please feel free to put them into the chat and we will certainly cover them if we have the time. So we'll put up our third poll just so we can sort of, again, get a sense of the audience. And I think we may kind of know this from the earlier poll, but the question is, have you considered investing in the cannabis space? Because if you have, we certainly have the expert here who can give us some insights on the risk and some due diligence that we need to do in order to prepare for that. So let's share that. We do have some audience members who have considered it. So Melissa, let's talk a little bit about this, shall we? I guess we should probably start by distinguishing the difference between what it is from an operator on the business side of cannabis versus an investor in, possibly the real estate that's related to cannabis. So can you kind of give us a little bit of background on both?
Sure. So I guess and sometimes you hear these terms used somewhat interchangeably, but there's definitely a difference to be drawn out as I start talking about constructing a team, which is something that becomes very important when you're considering going about a cannabis endeavor. An operator is somebody who's crucial to have on board, multiple operators in some cases, because they're the ones that have the skills and the know-how to actually make the business run, to actually cultivate the plant, or to source the plant in a supply chain situation where you're not what's called a vertically integrated entity. So I guess for just a little bit of history, the state of New Jersey, since the inception of the medical cannabis program, has issued licenses out to operators who have been, I'll use that term again, vertically integrated, which means they run the supply chain from seed, the point that it's planted into the ground and actually becomes a product, to sale to the end consumer. So they have all components of the supply chain within their entity. So where we're starting to head now, as adult use becomes legalized and they open up, the state of New Jersey opens up more licenses for new operators, new applicants to come in and take advantage of the market, is such that you don't have to be a vertically integrated operator. You can go ahead and only open a dispensary, only open a cultivation center. And we'll talk a little bit about the pros and cons of each one. But what it means is that from an operating versus an investing perspective, everyone comes to the table with a different set of skills. And the most important one that you can have, as important as it is to have a strong lawyer, a team of lawyers, a strong CPA to be able to get your accounting processes and procedures in place, and very importantly, your internal controls in place, somebody who really understands business and management. The most important thing you can have among that team is somebody that actually understands the cannabis business. And that is whether it's standard operating procedures related to growing the plant, or again, importantly, being able to source product in a supply chain that is ultimately very crunched right now. Since the passage of the Adult Use Act, which allows us to purchase as non-medical patients, we can walk into a store as consumers. The supply chain has just, it's very difficult for dispensaries to keep product on the shelf. The state's plan to deal with this is to issue new cultivation licenses to be able to expand supply in the state of New Jersey. But as of right now, with a 3 to 6 month cultivation period for product to be able to hit the market, and a number of licenses, they're saying that there's going to be, I believe it's 37 cultivation licenses until around this time next year. There's still quite a ways to go in terms of refueling the supply chain. So that's a long-winded answer to say an investor is somebody on the team, and I'll refer to the team a lot because it really does take a team of experts to be able to open a cannabis business that brings money or skills to the table other than those that an operator brings. An operator is somebody who understands how to cultivate the plant, or who's deeply ingrained in the industry and is able to assist in sourcing the product, maintaining the product, managing inventory, things of that nature. I guess the other thing that's important to point out in relation to that question is that the cannabis industry is relatively small and tight-knit, and most of the people who are in the industry have been in the industry for a long time. If you think about it, New Jersey, we're going on a decade of medical sales, over a decade of medical sales. So you have, again, what we call multi-state operators, people who have operations in states other than just New Jersey, more developed markets in some cases. They've been around for a very long time. Everybody knows each other, and all of the operators that already have this know-how are already ingrained in the market and aligned with the interests of other businesses. So trying to pull operators to a new endeavor, particularly a startup, is very difficult. So you end up having a small pool of individuals who actually know the industry, because the industry has only been around for a certain amount of time, and in a number of states, you have a very small pool of people to try and pull from to be able to get that operational expertise. Something that we're going to talk about in a little bit is some of the risks associated with becoming a new entry to this market. And a big piece of that is trying to obtain an operator to assist you on your team.
So Melissa, thank you for that background. Let's talk a little bit about the risks, right? And let's look at it maybe from more of the investment side as opposed to I want to be somebody who's going to run a startup and at the seed level, if you will, right? So let's look at it as any other investment. We need to do a risk reward analysis. We need to do some due diligence. What do we need to be on the lookout for specifically in the cannabis space from an investment in this industry? I know we talked a lot about credit and financing and capital intensivity, the intensive nature of the capital and needing to have funding for losses. So what are some of the things that investors need to look at specifically related to cannabis?
Sure, it's a great question, and I'm kind of laughing here because I don't know if everyone else feels this way, but when Keya is talking and I'm in the presence of a lawyer, I always feel so safe. And that he knows the rules in and out, like how to advise clients in terms of operating in this gray area, and it makes me feel at least very safe. I love lawyers for that reason. In my world, I feel like it's the total opposite. And you might walk away having heard what I have to say about risk and be like, well, why would anyone ever get into such a risky area with so little established history to understand how to evaluate these types of investments? And I think that's in part, it's an important consideration because it really is a very risky area. So Sarah, you mentioned a couple of what I would call the high profile, high ticket items. Being able to, and I guess I should preface this by saying that a lot of the risks that I'm going to talk about overlap, whether you're thinking about being an operator or an investor, because as an investor, your reward, your potential reward and your potential risk are directly tied to what the operators are doing and how they're able to succeed and turn a profit. So it's some of this stuff might sound more nuanced for an operator, but it's actually very important for investors to consider as well. So as a cannabis company, and a lot of this stems back to what Keya was talking about before, the federal illegality under the Controlled Substances Act. Cannabis is still classified as a Schedule I controlled substance, the highest level of warning that can be attached to a substance in the eyes of the federal government. And absent that legislation passing to change that, to either deschedule it or to move it to a lower level of scheduling, there are just so many business implications as you're trying to deal with this federal and state disparity. So it's legal for state purposes. You have a license that says you can operate this entity versus, on a federal level, the product still being illegal. And of course, the ironic thing to point out that Keya mentioned a moment ago is that this is a substance that's administered for medical purposes. States have cards that they give to people that say your medical issue can be dealt with using cannabis, and yet the Controlled Substances Act says that this is a substance with no medicinal benefit. So there's that huge disparity that I just find so ironic. So as a result of that classification under the Controlled Substances Act, access to banking is very, very difficult. There is only a number of financial institutions that are willing to deal with cannabis clients, particularly plant touching cannabis clients. The market has definitely opened up a bit more since 2017, when we were only talking about a medical market. But one story that I like to tell as an example is I was working with a nonprofit. It was a 501c6 organization that was had its member base comprised of cannabis operators. Non-plant touching had absolutely nothing to do with the plant. It was a professional organization. That organization struggled to get a bank account with the major banks because of the fear that they had surrounding the closeness to the plant. And again, I can't emphasize enough that organization was non-plant touching, but merely its member base was comprised of operators. So that became a huge issue, trying to get a bank account just for that professional organization. Now think about if you're handling in the cannabis space, you're actually an operator. Again, there's only a small number of banks that are willing to touch it, at least at this point in time. So similarly, if it's difficult to get banking, it's nearly impossible to get financing. Again, the market has opened up a little bit more, and there are companies that have figured out ways to get comfortable with the risk associated with lending to a cannabis company. But generally speaking, it's incredibly difficult to find. And when you do find it, you're paying what many like to refer to as a cannabis tax. So, and this is the same on the banking side, by the way. I should mention that fees associated with banking a cannabis company, when you can locate a bank, are much higher than what a non-cannabis counterpart is going to experience at a bank. And the reason for that, it's not necessarily supply and demand price gouging practices. It's that the banks have to a much higher level of compliance associated with taking on a cannabis operator as their client. So banks have to file what's known as SARS reports, suspicious activities reports, when customers come in with transactions that meet the criteria of what a bank deems suspicious. If you're a cannabis company, because you're dealing with a federally illegal substance, every transaction that you go to your bank and execute is considered a suspicious activity and needs a SARS filing attached to it. So there's an incredible level of compliance that comes along for a bank who's willing to handle cannabis companies, which is why the few that do it, they really have gotten comfortable with the process. They know the process. They have it down to a process so that they're able to better manage those clients and be able to do it practically. So now going back to financing, again, the financiers are worried when they go to lend to a company and they look at your balance sheet and they say, okay, here are the assets we can possibly attach ourselves to as collateral for this loan. When you're operating in the cannabis industry, you have to remember that, again, technically, even though, as Keya mentioned, the federal government has taken a hands-off approach over the last couple of years, and they're not enforcing violations of the federal law as it pertains to cannabis, lenders look at that and they say, well, wait a minute, how do I know that the assets that I'm attaching myself to aren't subject to federal forfeiture, for example? There are laws, pending laws that hope to deal with this. So Keya mentioned the MORE Act. There's also the Safe Banking Act, which really seeks protections for financial institutions. It would open up the market basically for banks to be able to handle cannabis companies without the concern that federal regulators are going to come in and take away their charter, as an example.
And Melissa, it's those commentaries on banking and financing that I think we are hearing from a lot of our clients. So much interest and conversation around investing in cannabis, because what we consider the traditional lending, startup money and line of credit operations are really just not necessarily as readily available to this industry.
That's right. Even something, Sarah, like a line of credit or a credit card, things that business owners are well used to having at their disposal, you can't get it as a cannabis company. If you're a cannabis company, the major credit card carriers are going to shut down your account the moment that they learn that you're dealing in cannabis. And if you try and circumvent those rules by, putting a credit card in the name of a manager and using it for business purposes, or put it in the name of one of your investors and use it for the purpose of the cannabis entity, you're running the risk of them shutting down that account and then putting you essentially on a blacklist where they say you're trying to circumvent our rules and we're not going to do business with you when this is eventually allowed for our purposes. And again, it all stems back to that federal illegality. So yeah, just know that anything associated with finance in the cannabis space right now comes with what they're calling, again, a cannabis tax. And so this is where I kind of come full circle. And I was talking about the team a moment ago and who you're assembling to go about this endeavor. And again, there's two types of investing, right? I can go to the stock market and purchase shares in one of the funds that has all the publicly traded cannabis companies, or invest directly in a publicly traded cannabis company. That's very different, right? You're very far removed from the actual investment, absent maybe being able to attend a shareholder meeting that they have annually. You're really not getting a lot in terms of understanding where your money is going in an investment of that nature. But then there's the kind of second level investing where you're getting a little bit more hands-on. You're giving a direct investment to a team of operators. Maybe you're obtaining a share of equity in accordance with the operating agreement. Maybe it's a debt investment. Most people want a piece of these things. So generally what we're seeing is people investing with the hopes of obtaining equity. But of course, it becomes a question of, well, who are you dealing with? And I'd like to emphasize that the cannabis industry is small and most everybody knows each other and has been working together for an extended period of time. So there's this new entry risk where you're coming in and you're trying to build relationships with people who have already been in the industry for a long time. And you need that because you need an operator. Now, I do get calls quite frequently from individuals who don't have that operator on their team yet. And oftentimes who they are is they're folks that are looking to open a dispensary. We're going to talk about 280E and what it is, but essentially because of the way 280E works, which is the provision of the tax code that says you do not deduct your business expenses as a cannabis entity. The worst thing that you can get into in cannabis right now is a retail only, a dispensary only operation. And it's just because the cost associated with doing business is so much higher. But without having an operator who understands how to grow the plant, how to extract oils and concentrates from the plant to be able to create even more sophisticated products than just the flower itself, that's something that takes a lot of skills and expertise that people just don't really have yet in New Jersey because we're such a new market. And to the extent people do have it, they're generally already affiliated with one of the multi-state operators. It's just the reality of the situation. So assembling the team, having the know-how and the skills on the team is incredibly important. The few other things that I will kind of gloss over so we can talk about taxes, which I think is a particularly exciting topic. Of course, having control over your investment, having a very clear, if you do go into an equity-based agreement with a team and you're looking to invest in a cannabis operation, having that operating agreement is important for any business, particularly in cannabis. Something that I've noticed during my time in the space is that it's a business for sure, and you do find a lot of sophisticated business minds. You also find a lot of emotion, which is quite an interesting area. It's a very creative space, and I think for that reason, there's a lot of colorful characters. Constructing the wrong team, not having the appropriate skills in place to be able to be successful. And then there's the market risk. We're not sure how the New Jersey market's going to shape up yet. I read that I think we had $2 million of sales in the first day that the adult use market opened up, which is incredible. Colorado is a $2.2 billion market annually, looking back to 2021. So, we have some idea of how big the market's going to be, but we don't know yet how many licenses are going to be issued. We don't know what the supply chain is going to look like. So again, there's really a high level of risk associated with being a new entry to the market. From a real estate perspective, a lot of times, getting a lease agreement in place with a cannabis company is difficult. So you see folks setting up corporate structures to kind of circumvent having the plant touching business be the lessee. Again, because of tax reasons, if you purchase a property under 280E, you're not going to get the full benefit of the deductions that come along with owning a property. The risk of bankruptcy, this is a very gray area, but generally cannabis companies, because of the federal legality, can't take advantage of federal bankruptcy. So, coming up with an exit plan in the beginning is challenging. And I know nobody wants to think about an exit plan in the beginning, but it's incredibly important, especially in an industry that's so high. It's such a high cost to operate in. You have to think about that exit plan. You have to think about how are we going to liquidate if necessary? What options do we have to sell our company and what we've created to somebody else who can fund the operations a little bit longer than we were maybe able to. These things all have to be thought out.
So Melissa, lots of risk. And you alluded to 280E, which, is a tax term and a code section that I do want to just in the last few minutes sort of have you explain to the audience what that is, because, we think about investment, we think about risk reward, we think about recouping our investment plus some, and what does 280E actually mean when we're talking about a cannabis business and the tax impact of those earnings and that revenue?
Okay, yeah, so this is a big one, and I would be surprised to learn that most people hadn't heard of 280E before, because it's so prevalent of a business issue for cannabis companies. It's essentially the specific code section in the revenue code, the IRC, that says you essentially, if you're in the business of what they call trafficking an illicit substance in accordance with the CSA, Controlled Substances Act, Schedule 1, that you're not allowed to take any business deductions with the exception of your cost of goods sold. And think about it for a second. You're a business owner. There's so much that goes into making that business run, and we're very incentivized to spend and invest into our business from a tax perspective because it helps offset the taxable income. Your things like your rent, your utilities, your payroll, generally become largely undeductible as a cannabis business. So I want to kind of emphasize it because it's mind-blowing. You cannot deduct most of your expenses when you're calculating your taxable income at the end of the year. So what ends up happening, to kind of paint a quick picture, if you made $1 million throughout the year, is a very simple example, and it cost $200,000 for you to obtain your product, your cost of goods sold, you have $800,000 gross profit. On top of that, you have $500,000 of business expenses. So you have a net profit of $300,000. You're paying tax on the $800,000. And oftentimes, I mean, if you have a loss, now you have to dig deeper into your pocket to be able to fund the tax liability. And if you have income, oftentimes that income is largely wiped out because of the high effective tax rate that you're going to pay. So where this becomes a little nuanced is depending on how you're structured, is depending on what you're able to allocate into your cost of goods sold. So if you're a producer, the tax code has a little bit more leniency in terms of what's considered incident and necessary to produce your product, which is what you're able to allocate into your cost of goods sold. If you're a reseller, you're essentially stuck. There's not much that you can say is incident and necessary to get your good from the person who produced it to the point that it's ready to now sell to your customer. What other costs are you realistically incurring that you can make a good faith argument should be allocated into cost of goods sold? So the corporate structure, the point in the supply chain that you choose to go after, which, as I said, many people are calling me nowadays saying that they want to open a dispensary, and I'll usually do a quick projection for them and show them the implications from a tax perspective. And I've talked so many people out of wanting to go this route because it just doesn't make sense while 280E is enacted and in place, and to get 280E to go away is as simple as descheduling cannabis so it no longer falls into that Schedule 1 category. But there's just been so much of the IRS pointing to Congress that you need to, deschedule cannabis, and Congress pointing to the IRS saying, no, you guys need to change the Internal Revenue Code and get rid of 280E. Nobody wants to take responsibility. And at the end of the day, the federal government is reaping a lot of profit from these cannabis companies paying this very, very high effective tax rate. So I know that that's a lot that I just kind of shoved into a quick spiel, but that's really, when we're talking about the risk and the cost associated with cannabis, that's one of the biggest ones to consider. And again, this is where it comes full circle. When you're thinking about which type of entity you want to invest in, to be able to latch on to somebody that's looking to do cultivation requires the highest level of skill and expertise and know-how. So it comes back to, where are you going to get that skill and expertise to be able to go ahead and try and open a cultivation facility? And to kind of compound on all of this, the guys who have been and gals who have been around doing this the longest, the existing operators, the multi-state operators, they've been paying 280E tax at an exorbitant tax rate for so long. There is going to be a huge benefit for that first to the market positioning. and they're really going to be the ones that reap the reward of this industry. So I always, throw back in a lot of caution when people are talking about entering this industry, and not attaching on to somebody who's been doing it for a long time.
Right. Thank you, Melissa. That was a very fast hour and certainly a lot of information. We did have some pre-sent in questions with registration, and we did have one or two come through in the chat. We don't have time to answer them at this hour, but we will have Karen and Brittany work behind the scenes to get answers to these questions, and they will go out with the follow-up email that includes the recording of this presentation as well. So I do want to thank both Keya and Melissa. You guys were a whirlwind of information. Some of us may be left with more questions than answers, but that's always a good thing to keep us thinking and digging deeper to learn more. So I do want to thank you guys for joining us today. I want to thank our audience for joining us this morning. If you do have any ideas or requests for future topics for SKC office hours, please reach out to Karen or Brittany so that we can add them to our list. Thank you guys so much for joining us, and have a safe, happy, and healthy rest of your day. Take care, everybody.